Hello and welcome to the Rogers Brief for December 2nd, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. I'm going to get to some interesting stories this week from the legal world in Nova Scotia and a little bit across the country. I'm going to talk about some cases that the Serious Incident Response Team, the SiRT, the Oversight Board or Oversight Mechanism for Police Actions, is taking on a couple of prominent cases. Looking at that and looking at a Court of Appeal has really come down pretty hard on some comments from Judge Alain, Provincial Court Judge out of Truro. So I'm going to talk about that and talk about some of the comments that Judge Bégin made that drew such ire from the Court of Appeal. The case of Randy Riley, this is the murder case that was overturned, I guess, and not guilty verdict this time around, a retrial. Issue came up with the Witness Protection Program. I'm going to talk about that. I'm going to finish off with some litigation that's going on in Ontario, and the Canadian Civil Liberties Association has become involved, and it has to do with housing and these encampments, tent encampments that we're seeing pop up in just about every city, major city across the country. So I'll get to that. There's some litigation ongoing there, and some guidance has been, I guess, provided from some courts already. But I'll talk about, actually, I should mention last week, of course, I did not post a Rogers Brief. I was away for the weekend, an extended trip over to St. John's, Newfoundland to play a little hockey with some guys from Nova Scotia. Anyway, I want to follow up on my last episode. I spoke about this manslaughter charge that's coming out of the UK with the hockey player on the ice whose skate blade clipped the neck of his opponent, and Adam Johnson, who died thereafter as a result of the skate blade injury to the hitting his neck. So he's been charged, the other player, with manslaughter. Well, there's a process where he's going to be probably charged with manslaughter. Anyway, it's a little different over there, but so my view was that this was a very quick, hockey play, an accident that happened, and sort of a freak accident. Some of the guys that I was over there playing hockey with, who saw it and looked at it in slow motion many times, they said they think he was trying to, the other player was trying to kick Johnson as he was coming across. They kind of lost position and was trying to kick him, and so intentionally tried to kick. Well, if that's the case and the court finds that was, he was actually trying to kick somebody, which you can't do. It's more, and it's a penalty, but it's more dangerous than that. Then he may be facing something, but it wasn't the way I looked at it. Other quick things before we start into the stories. Just looking down at the States, and I see that the former President Trump has lost an application. He was seeking to have a declaration that as president he was, and a former president, immune from criminal prosecution. The courts have said no. Two of them actually have said this. No, just because of that, you're not immune as a former president. But if you can show that what you were doing, particularly on the January 6th stuff and trying to, and the Georgia election, declaration, certification case, if you were doing it in the course of your presidential duties and you can show that, then that is a defense, if you can show that. All right, so keeping an eye on those things. Not a lot of applicability, in a sense, to Canadian law, since their system is quite different down there in those regards. The other thing, just following up on, this came out last week, but of course when I wasn't posting, I didn't get to talk about it. The Cameron Ortis case. This is the head of the RCMP Research Division, involved in some espionage, counter-espionage circles in Canada, accused of trying to sell information to money launderers, has been convicted by a jury of trying to do so. Well, anyway, I had been following that trial. So much of it was in secret, so hard to get a good read on it. And of course, you're just reading articles and coverage of it too, so it's always hard to get a read on it from that way. But I saw the reaction from his lawyer, who was a very experienced criminal lawyer in Ottawa, saying that he was disappointed in the jury system, had never felt such, such loss of faith in the jury system as he did after this verdict. So you think, okay, well, that's just sour grapes. You lose a case and you're going to say something like that. Well, this seemed like more than that. And of course, the defense lawyer is going to have quite a bit of insight into it. So we'll see. We'll see what happens there. He says he's going to appeal it. Very difficult to appeal a jury verdict. I've done it once successfully. I mean, that's a very, very rare thing, because you don't know what the jury has thought about typically in their deliberations. Well, not typically. You just, other than hearing what the verdict is, you don't know what they were really thinking. So usually on a jury verdict, you have to attack the judge's instructions to the jury. And so I'm sure the instructions in the Cameron Ortis case are going to be examined very closely at this stage, and we can expect an appeal to be filed sometime, well, I guess in the next couple of weeks now. Okay, let's get into the stories that I was going to focus on this week. The first two involve the Serious Incident Response Team, SiRT, in Nova Scotia, and this is the agency that reviews any activity by police officers for the potential for criminal charges to be laid against police officers. So whenever there's use of force, any allegation of sexual misconduct, anything like that, a file is sent to SiRT, and they determine whether charges should be laid after an investigation. And they have some staff. They have a director. Now it's an interim director, and this is Erin Noss, who is a lawyer. She was I knew Erin Noss a little bit. Now, we articled at the same firm. I was a year ahead of her, so I didn't know her well, and I didn't really. I know she had a good reputation at the time, and of course that Cox and Palmer, or Cox Hansen at the time, that was. She came out of UNB, so she was a high achiever at that point. And I knew she went off to the Federal Department of Justice for some years and hadn't really kept up on her career. But now she is the interim director at SiRT after the former director, Alonzo Wright, was named provincial court judge. And before that, there was an interim director, I think, former Judge Pat Duncan, and before that it was Director Felix Cacchione. So there's two things going on. One is a reconsideration of former Justice Cacchione's and Director Cacchione's conclusions in the Mass Casualty Commission incident at the Onslow-Belmont fire hall. And people that have been watching my videos and following along in the news will know what happened there, which was two officers showed up, pulled up short of the fire hall, saw a police vehicle and a person in a vest, and opened fire. The SiRT investigation cleared the two officers, but many people, firefighters, community members in the area that witnessed the incident, me, who went to the site and said this couldn't possibly be the way they concluded it to be, and then the Mass Casualty Commission was quite critical of it all as well. In their report, Mass Casualty Commission actually had 16 pages on Onslow-Belmont, whereas the SiRT report, the full report, was only 6 pages. So what now? So the SiRT legislation allows for a referral from, a referral to an outside agency, and in this case, it is being referred to the Ontario equivalent of SiRT, and they're going to come down and do an investigation. But problem is this: the initial SiRT investigation cleared the officer, said there should be no charges, and that is supposed to be determinative of the outcome. So after that SiRT investigation cleared the officers, the two of them went and testified at the Mass Casualty Commission and, said what they said. Well, now the SiRT release is saying new information came up as a result of the Mass Casualty Commission report, and so now they feel they can investigate it again. If you were the lawyers for Brown and Melanson, the two officers, you would say that's an abuse of process, that perhaps they would not have testified, or they would have testified, under different circumstances with different preparation, but probably wouldn't have testified if they thought they were still at risk of being exposed to another investigation through SiRT. So be curious to see what happens. By the way, also, so I think if the new information, whatever it is something that could have been discovered without their testimony, or aside from their testimony at the Mass Casualty Commission, then maybe it can be used again. But I'd be curious to see what the investigation unfolds. Probably take a few months for that to take place and get a report on it. The other one they're doing, that SiRT is doing, is opening up. Well, they'd already done this. So back a couple of years ago, I think it was 2020, the Justice Minister, Mark Fury at the time, asked SiRT to investigate the wrongful conviction of Glen Assoun. Glen Assoun was convicted in 1999. 2021, SiRT asked the British Columbia Independent Investigations Office, which is their equivalent of SiRT. Actually, it is headed up by Ron MacDonald, who's a King's Counsel lawyer, former Crown prosecutor out of Antigonish, somebody I knew quite well when I was starting out in practice. Very good reputation as a prosecutor. He was the first head of SiRT in Nova Scotia. Did a good job there, had a good reputation. SiRT developed a good reputation under his leadership, and then he went off to BC to do the same thing out there, and from all reports has been doing a good job. Well, in 2021, it was their agency, the BC agency, was asked to take over the Assoun, or to do the Assoun investigation. But in April 2023, this year, they informed, so 2 years afterwards, informed SiRT Nova Scotia that they were too busy. They had too much of a workload and cannot continue or do the investigation. Unclear from any of the information we have so far how far, if at all, into the investigation they've already gone. So apparently, what the release from Aaron Noss says is that since April of 2023, they've been looking for an outside agency to take over this investigation from the BC one. One would presume, just based on the fact that SiRT asked the Ontario agency to look into the Onslow-Belmont situation, that they've also asked the Ontario agency to look into this one, and maybe been told no, one at a time, or something to that effect. So the question is whether and who might take on this Glen Assoun investigation. Looking into some of the actions of the Halifax Regional Police in that case. Question I had when looking at this is, what about private investigators? There are private investigators in Nova Scotia, former police officers, others with good reputations, who could take on a task like this. But here's the problem. The legislation in the Police Act that creates SiRT allows for the director to get an outside agency to do it, but not an outside private investigator to do it. So might be something they look at. I mean, you have, instead of flying investigators in from British Columbia or Ontario or whatever, housing them, all of the expenses that are associated with that, hire a private investigator to do it. They wouldn't be as, or maybe be seen as being beholden to the police in the same way that an agency, an official agency like SiRT, who still has former officers. There's some allegations that they work too closely with SiRT and such, so maybe private investigators would overcome that kind of reputational issue. However, on the other side, a private investigator doesn't have what I could say is the institutional legitimacy of a SiRT or a SiRT equivalency in some other places. So we'll see how Aaron Noss has, that is, committed to maintaining public profile on this issue, and that she's going to keep us informed of whatever happens next. So good for her in both cases. Maybe she's enjoying the job and doesn't want to just be the interim director, but a permanent director. So we'll see how that goes. Now, next case I want to talk about, and this was in the news this week in Nova Scotia. The Nova Scotia Court of Appeal came down and described the behavior of Judge Alain from the court of the Provincial Court in Nova Scotia as astonishing behavior, and then startling language. All right, so what happened? There was an accused. So this is a case where initials are being used because it's a sexual offense, sexual assault, sexual invitation to sexual touching, and sexual interference case. A guy and his stepdaughter. She was 14 when she reported. Said that the guy had been abusing her since she was in grade 3. So some bad stuff. But initials are used to protect the victim's identity. So R versus KJMJ. And so the accused was on trial. And when they got to the end of the evidence, after the evidence was all in, then the Crown and the defense asked the judge basically, where would you like us to focus our closing arguments? Okay, which can be helpful to have the judge tell you where their thinking is, or where they want you to pay the most attention, but it has to be done in a certain way. So what happened here? The Judge Bejan was asked, sort of for preliminary thoughts, or was going to give his preliminary thoughts, and this is what he said. Is he swimming with angels? Look at me, sir. Is he swimming at angels and totally innocent? Absolutely not. Does he have issues and invited some young child to do stuff to him? Absolutely. Zero doubt in my mind. He's got issues. Yeah, I'm looking at you. You've got issues, sir. You've got sexual deviance issues. There's no doubt in my mind. Is it proven here? Probably not. Do you have issues? Yeah, you do. Should you get them fixed? You should get them fixed. Do you understand? And then some other comments. And the judge says again, he'd be guilty of count 3, inviting a child to do stuff. That's where I'm at. Sexual assault, I'm not so sure. It goes on from there. So that was one thing. Then the Crown suggested, well, we'd still like to make submissions, even though you've sort of shown us where you're going with this. And then Judge Bejan says about his earlier comments, while it was recorded, it's an off-the-record comment and won't form part of the transcript because I was invited to give some initial impressions, and I gave my initial impressions. I honestly don't know where I'm leaning on this for the most part. And then a few moments later he said, so when they prepare the transcript, make sure they don't have my comments from when we sat back and talked. Okay, so last part was really where he got himself on the wrong side of the Court of Appeal. The Judge Bejan attempted to have those comments not form part of the record. So whenever you appeal a case, the entire transcript, all of the evidence, exhibits and such are sent to the Court of Appeal, and that forms part of the appeal record. Well, Judge Bejan was claiming in an email, he claimed privilege over those comments. And the the Court of Appeal said that's just not on at all. That there is an open court principle. That violates the open court principle and the strong presumption that justice should proceed in public view. Now, I will say, as a lawyer that does a lot of criminal work, it can be helpful, or any kind of litigation. If you present your case to the judge and all right, well, where would you like us to focus our arguments on, on which count or which whatever, it can be helpful. I think probably the safer route is what normally happens, which is to make your closing submissions, and then if the judge has any questions, then the judge asks those questions and you answer them, and then the judge presumably at that point has a a fulsome understanding of your position, and hopefully, well, if you've been able to answer the questions in a way that's persuasive, then great. And if you can't, then that says something too, and the judge may rule against you or against your client. This thing about and it's not terribly unusual to have some conversation from the two lawyers and the judge up at the bench, but that's all recorded, and everybody knows it's being recorded, and there's no going and putting it back, putting the toothpaste back in the tube. I mean, it's a different thing. Like, all right, the trial's over, and the audio recording has stopped. The judge might say something, might say, hey, or ask about the family, or have some other conversation after that has nothing to do with the trial or anything else or whatever, and that's fine too. But if it's recorded, it's part of the public record, and there's no putting that back. So, mistake by Judge Bégin there to try to make any kind of a claim over that. So we'll see. I suspect it's going to be a new trial. Unfortunate for the people involved, the victim in particular, who's now going to have to testify again. Hard to say too. I mean, anyway, it could end up as a plea deal on a retrial. Once you've done a trial once, you usually don't need to do too much work the second time around to understand what the outcome's going to be. Okay, so that was. See if there's any other consequences for Judge Bégin there. I'm sure he's not too happy with that, the way that unfolded. Okay, next case I want to talk about is this Randy Riley decision, and it was a decision after the trial was over. Randy Riley was convicted, and then his conviction was overturned. He spent years in jail, and part of his conviction rested on the evidence of this Caitlin Fuller, who was a witness, girlfriend of the real killer. So she was for several years in the witness protection program. The cost of her protection in that program was over $600,000. So, but her credibility was a key issue during the retrial. She was found to not be a credible witness. She was attacked by the defense for trying to milk the system, milk the witness protection program. So what happens afterwards, the witness protection program decides they would like, they saw some articles in the Halifax Examiner. I think CBC had posted some articles as well that identified Miss Fuller and the witness protection program and the amount. There was an order in the trial that prevented the media from publishing anything that would identify, that you couldn't publish a photo of her, couldn't describe her in a way that would identify her, and that was it. But otherwise, you could say how much she was in the witness protection program, how much it cost, and some other details. So everybody complied with it during the trial. But afterwards, the witness protection program tried to get a retroactive publication ban, because they said, just as the overall, I guess the mosaic of information that came out during the trial, if somebody knew her well, they might be able to identify her, and these kinds of things. So they wanted it all banned retroactively. So this was unusual. That's the way Justice Josh Arnold treated it. Justice Arnold was the trial judge. Certainly one of the top trial judges in Nova Scotia at this stage, I think would be a fair comment. He was the top criminal lawyer before being named a judge. And he said, no, you can't do that. Everybody did it properly during the trial. You can't retroactively go back. And he made some comments. By the way, witness protection program, here's what you should have done. You should have asked for a different order at the beginning, because you had all the disclosure. You knew exactly where the defense was going to be going with this, because they asked those questions at the preliminary hearing. And by the way, the witness protection program people didn't even show up. There was nobody in the courtroom for her 2 days of testimony from the witness protection program. that would have been there to take notes and, show concern or do anything like to say, oh, geez, something, she's being identified here or whatever, anything problematic. They weren't even there for a testimony. They just complained afterwards. So clearly, I would say, the witness protection program was embarrassed by being exposed as having been manipulated by Miss Fuller, and they didn't want people to know about that, and so they were hoping for a retroactive publication ban. Didn't happen, and so there should be more questions about this witness protection program, leadership, administration, all of those things, the way they were used in this case. All right, last thing I want to talk about is housing. Everybody's seen this across the country. Major cities, Halifax and Sydney for sure. Other places, smaller towns are seeing it too. People are doing whatever they can for housing. So, terrible situation in many cases. I've seen this in my work too, of people staying in bad situations sometimes because there's nowhere else to go. But people are trying to winterize trailers. They're staying in tents. Tents are the big thing. So some cities are trying to deal with this by removing encampments, and these encampments are forming up in different parts of the city, often on public property, municipal parks, in some cases, or underpasses, anywhere where they can get a power hookup, some shelter from the wind. So people are sort of choosing their locations, in some cases within ball fields for security purposes, for shelter purposes, and all these things. So how are the courts going to view this? Because in London, Ontario, there is an attempt to remove encampments, and they're fighting back, the encampment people, and the Canadian Civil Liberties Association has filed a brief in support of the homeless individuals, people in tents. And so what's going to happen? So I was reading through the brief, and it referenced a couple of cases that have already been decided, and so I can kind of see where I think this is going. The Civil Liberties Association is trying to show that there is an overall right to housing under the Charter. Well, other courts have already come to that conclusion. Windsor, Ontario, and Victoria, BC, there have been decisions arising from encampments there. And the conclusions basically are, yes, shelter is a necessity of life. And if there's not enough housing in a certain area, and then there's not enough shelter housing, so what they call low barrier accessible housing, a shelter where you can go, and then with some security of the person as well. And then they talk about all kinds of different situations too, where couples are able to stay together, or people with different needs. Sometimes shelters don't work for everybody either. And then there's discussion about security during the daytime. Is it just for sleeping, or is it longer than that? Seems to be the conclusion that where there's evidence that there are insufficient shelters, and that's most places. There was 1,000 in the Windsor situation. There was, I think, 1,000 too few shelter beds for the number of people that were out there looking for them. So if there are inadequate shelter beds, then within reason, these tenters are going to be free to choose the public space that suits them and that works for their needs. As long as there's some balance between the overall public use of these parks and the actual vital need for these people to house themselves, have shelter, be able to survive the cold conditions, then those people are going to be allowed to stay there. I think I see that this line of reasoning, I suspect that it will be likely adopted throughout the country by courts. So if cities, if municipalities are looking to use the courts in order to support their efforts to remove encampments from public spaces, I think they're likely to lose those cases. Of course, there's there's going to be specific differences in each case, but the general thrust of these decisions seems to be allow that freedom of people to choose the place that suits them best in public if there's no other low barrier accessible housing available. So I think the solution, instead of using the court systems, if municipalities and cities are looking to do that, is to build more shelters. Take in hotel beds, do something, and find some shelters for these people. So some interesting stuff. I mean, this is going to be a situation that, it's already across the country everywhere. It's a terrible thing to see, and they're going to have to find some more adequate solutions to that. Okay, so be looking. So tomorrow night I'm going to be on the Sunday night show with Jordan Bonaparte and Paul Palango. By the way, talked about this SiRT Onslow-Belmont situation last week on the show. Had Daryl Curry on there, the deputy fire chief from Onslow-Belmont. Really good episode, good discussion with Daryl. If you haven't seen it already, it's worth checking out. Check it out as a YouTube video or a podcast. And I'm going to be asking Paul this week about the Cameron Ortis verdict. I know he'll have some thoughts on that as well, so should make for some interesting discussions. I've already gotten some other stories sent my way from Paul and Jordan too, so it should be a good show tomorrow night. So look forward to that. And we'll be back next week with another Rogers Brief. So I hope everybody's enjoying their early December, getting their Christmas decorations up, all those good things. And so thanks again for watching. Thanks for listening, and we'll see you next time.